Stop. We could have stopped for expired tags. There was a smell of fresh marijuana emanating from the vehicle. It admitted to marijuana and pills being in the vehicle. PC search located approximately 60 grams of marijuana, 5 grams of Fazalone, Xanax. Fazalone was located in the Ziploc style baggie directly behind the driver's seat, which Mr. Arturo was sitting in. The substance was within arm's reach of Mr. Arturo. Defendant confirmed with the Deputy Alvarado on 6.
Mr. Ampur, I see that you have quite a significant criminal history. I'm not going to put up with this. And I'm telling you now, you cause me any heartache, I'm going to put you in jail. You will not get any more PR bonds. I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir? You are not allowed to drive. You will be signing an affidavit with me, promising me you're not going to drive today. I don't care what your excuse is. Do you drive? I will have a contempt hearing. You'll be facing an additional 6 months every time you get in a car because it's an offense in and of itself. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope or unprescribed controlled medication, you will go to jail. If I see that you have continual problem of not being able to stay sober, I'm going to put you in a rehab myself, and I promise you, you're not going to like the way that I address it. So if you have any demons, you better stop it by yourself. If you don't, I will do it for you. You understand? What do you do for a living, sir?
I work at a warehouse. I used to work at a warehouse, shipping and receiving. I know that it looks really bad.
All right, guys. This courtroom hearing exploded into chaos almost immediately after police described a traffic stop involving marijuana, pills, and a loaded weapon. Officers claimed they smelled fresh marijuana coming from the vehicle before discovering large amounts of drugs, pills, and ammunition in side bags directly within reach of the driver. Prosecutors described magazines packed with bullets, marijuana packaged in separate bags, and enough evidence to make the judge visibly angry. But what really triggered the courtroom lecture was the defendant's criminal history. The judge made it crystal clear that he was completely out of patience. He warned the defendant that any future violations, especially involving drugs, alcohol, or driving without a valid license, would send him straight to jail. Then came the chilling promise. If addiction or reckless behavior continued, the court itself would force him into rehab whether he liked it or not.
I only wanted to know what you do for a living and how much money do you have coming in?
I'm currently unemployed.
You're what?
I'm currently unemployed.
Why?
I've walked away from a position recently because it was just a hostile environment.
Are you high right now?
I'm just very nervous. Just very nervous.
You look high right now.
No, I'm not. I'm just very nervous. I'm trying to just take it in right now. I haven't been in trouble in 6 years. I switched.
You just had a falsifying your drug test dismissed a year and a half ago.
Yes, but I got it dismissed and it was for a good cause. I've switched everything around.
Please.
All right.
No drugs, no alcohol. I'm going to test you like crazy. Do you understand?
I won't.
I'm going to have you fill out an application now for an appointed lawyer. After that, you'll get to sign a reset with Victoria. I'm going to have you swear to us that you're not going to drive. Then you'll get with Jeremiah for your bond conditions. And after that, I'll have you speak to a lawyer here momentarily, sir.
Judge, are you ready for the Spanish arraignment?
Yeah. Ma'am, you were charged with assault, bodily injury. You were facing a year in jail and a $4,000 fine. You guys, you tell me, worked out a 12-month deferred, right? What are the conditions that we're going to do?
Thinking for a change, 4 hours anger management, 24 hours community service, and no threatening, harassing or abusive language to Nicole.
Oh, okay, hold on. That was really fast. So thinking for a change?
Yes.
Which one?
It's the 13-week course.
The 13-week? Okay. You said a 4-hour anger management class?
Yes, sir.
What else?
24 hours of community service.
Okay.
And no threatening, harassing, or abusive contact with the complainant, Nicole Jamies. Jaimes.
Listen carefully because this next exchange turned deeply personal. The defendant tried explaining that he had recently quit a warehouse job because of a hostile work environment, but the judge instantly cut him off before he could continue. He only cared about one thing, whether the man was sober and capable of following the court's orders. As the defendant nervously answered questions, the judge openly accused him of looking high right there in court. The tension became unbearable. Even though the defendant insisted he was only nervous, the judge wasn't taking any chances. Random drug testing, mandatory sobriety conditions, and strict supervision were immediately ordered. Then the judge issued another warning that sounded more like a threat than advice. If the defendant couldn't control his own demons, the court would do it for him. The message was brutal, aggressive, and impossible to misunderstand.
And no weapons.
No, she's 18 years old. Maybe look at that community service, maybe because she's working, literally she's trying to do her thing, trying to get off the ground.
What do you do for a living, Ms. Limbrick? Prove to me you're a student, and then we'll work on your community service. But I want proof, because I'm not going to take your word. And as long as you're a valid student and you remain so, we'll kill that part. I'm telling you now, you're on a very serious deferred, which is a type of probation that if you complete, you don't end up with a conviction. You can't tell people it was dismissed because it wasn't. You just did the probation, completed it successfully, and didn't end up with a conviction. You give up almost every right known to man by entering into this agreement, signing a contract telling us that you can complete it. If you don't, you're facing an entire year in custody. Do you understand? That means if you smoke weed, if you get into another fight, if you pick up a new case, don't do your stuff on time, I'm going to issue a warrant. I will put you in jail. The only thing that we're going to talk about is if you violated your probation. If you did, you're looking at an entire year. Do you understand me?
Yes.
Can you get this done? Can you get it done?
Oh, yes, I can. No.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged right to go to court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal, Ms. Limbrick, meaning that once you enter into this agreement today with me, you're stuck with this until you complete it or if it gets revoked. I will make this sweeter for you, though. If you can get everything done quick, you're nice to everybody, don't pose a problem, don't test positive for weed, I'll take you off in half the time. I'll reward you if you do really well. But if you do poorly, it's going to go sideways real quick. You understand?
Yes, sir.
If you ever have a problem, come back to us and talk to us. Don't just take off because that's the worst thing you can do. How do you plead to the offense, man? Guilty or not guilty?
Guilty.
Now the courtroom shifted to a completely different case involving a young 18-year-old woman charged with assault causing bodily injury. Unlike the earlier hearing, this one focused heavily on rehabilitation instead of punishment. Lawyers negotiated a deferred probation agreement that included anger management classes, community service, and strict no-contact conditions with the victim. But even while offering leniency, the judge delivered an intense reality check. He explained that deferred adjudication was not a dismissal or free pass. It was essentially probation hanging over her head for an entire year. One failed drug test, one fight, one missed class, or one new arrest could instantly trigger jail time. Yet there was also hope. The judge promised that if she stayed respectful, avoided trouble, and completed everything quickly, he would reward her by ending probation early. For the first time in the hearing, the courtroom briefly shifted from fear to opportunity.
I will not find you guilty. I will withhold that for 12 months. But like I said, get it done quick. We'll take you off in half the time. All right?
Sir,
Reduce your fees to the minimum, please. We'll give you credit to. Okay, ma'am. Good luck to you. Thank you.
Okay, thank you.
To your probation. Mr. Jackman, do you know why you're here? Why are you here? You got to pay your child support. Your kids need the money, man.
I do pay.
Evidently not. Otherwise, you wouldn't be wearing orange, right?
I understand what you're saying, Your Honor.
I will only give you one chance. The lawyers have asked me, and I will give you one chance and one chance only. You must go turn yourself into Michigan. I'm giving you 2 weeks to get that done. If you fail to do this, and I'm going to tell you now also, if they ever issue another warrant for you for this type of offense now, you will never get another bond. Do you understand?
Understand.
Pay your child support. We're giving you 2 weeks to go turn yourself in as well. You will not get another bond, Mr. Jack.
Yes, sir.
Okay, so let's set bond at $500.
Bond set at 500, waiver withdrawal's been e-filed.
Okay. So we will get you out of here today. Within the 2 weeks, you must either turn yourself in, post bond. If you do that, this fugitive case against you gets dismissed. If you fail to go turn yourself in or anything else, like what we told you, I will revoke this bond, set it at 0. It's not going to happen again. I won't get you and I'm going to hold you until they come and get you from, is it Michigan, right?
Yes.
So upstairs, it was 9 months county time or state jail time? Do you know?
Just when things seemed calmer, another defendant stepped forward wearing orange jail clothing over unpaid child support warrants tied to Michigan authorities. The judge wasted no time confronting him directly. He reminded the man that children depend on financial support to survive and made it painfully clear that excuses would no longer be tolerated. Still, instead of immediately sending him away, the court offered one final chance. The defendant was given 2 weeks to return to Michigan, turn himself in properly, and resolve the outstanding warrant. But the warning attached to that opportunity was terrifying. If he failed to comply or ever face another similar warrant again, the judge promised there would never be another bond offered. He would simply remain locked up until authorities physically transported him back to Michigan. The courtroom understood instantly. This was mercy balanced on the edge of disaster.
So you know that means it's day for day now. 9 months. Every day of 9 months you'll be doing upstairs. And let me tell you something. You have so many darn thefts on your record. You pick up another theft, you know what's going to be happening? Prison time. Because they can use all of your state jails to enhance you to a third-degree felony, and you'll be looking at 2 to 10 in the penitentiary. Have you been to prison before? It's that what it's going to take to get you to stop? I count what? 1 theft, 2 thefts, 3 thefts, 4 thefts, 5 thefts, 6, 7 thefts. I'm telling you, next time you're looking at years in prison, man. With us, you're charged with a theft and possession of a controlled substance. Which one are we going with?
PTS.
We're going to dismiss the theft. This is how you understand it, Ms. Arzol. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this, you can never come back and change this. I'm going to tell you now, if you so much as ever pick up another case, because I'm going to have jurisdiction over you for the next 5 years, I'm going to make your life a living HE double hockey sticks if you ever come back here. I'm going to make your life so miserable, you won't even know. Don't pick up any more cases. Do you understand? How do you plead to the offense? I will find you guilty. Do you know what sentence we're doing, imposing?
No. 20?
Do you know what, on Ms. Arzola, what we're doing? A chance?
20 days for 20?
Yes.
Judge, it was 20 days, Harris County Judge.
I'm sorry.
20 days in jail. I'll give you credit for the time that you've done. Good luck to you, man.
And finally, guys, the hearing ended with one of the harshest warnings of the entire session. Another defendant with a massive theft history stood before the court, facing both theft and drug possession charges. The judge began listing conviction after conviction, counting theft offenses one after another until the courtroom atmosphere became painfully uncomfortable. Then came the brutal truth. He explained how repeated theft convictions eventually allow prosecutors to enhance charges into serious felonies, carrying years in prison instead of short county jail sentences. The judge openly threatened to make the defendant's life miserable for the next 5 years if he ever returned to court again with new charges. Despite a plea deal dismissing one offense and reducing punishment to only 20 days in jail, the message could not have been clearer. The next mistake would likely end with prison bars, permanent criminal branding, and a future destroyed beyond repair.